So I had quite a few people comment on my last couple of videos, mentioning that they thought discovery ended on July 1st. Back when the judge first set up the scheduling order, I went over that with you guys. That was a long time ago, and there's quite a few new folks here who probably never saw that. Also, a lot of you hadn't seen a whole process like that before, so you might not have known what I was talking about at the time, which would have made it hard to remember. So I wanted to go through that schedule now that we were halfway through the year and just sort of review it. So after their first conference, he set up this schedule, and it's called the scheduling order. It lays out the most important deadlines all the way up until pretty near the trial. The first deadline was right away. It was initial disclosures. And in his order, he often puts the rule for them to follow when they're filling in these forms or submitting this paperwork. So for example, we see initial disclosures. The deadline was February 18th, and they were to follow Rule 26A1 of the Federal Rules of Civil Procedure. So this one is a form, and it's kind of a basic outline because that's all you can really have at that point. This was brand new. But each side has to fill in this basic information and provide it to the other side. So these are the list of possible witnesses they might have and what their discoverable information is. It also includes lists of documents or other tangible things that they will probably use in their case. This tells the other side what sorts of things they should request from them. So it's a brief outline of their case as it stood at the very beginning. And of course, a lot more details get filled in later. But that was the very first deadline, like I said, February 18th. Then based on those, we get our next deadline, and that's March 14th, and it was initial requests for production of documents. This is after you've seen the list of what opposing counsel plans to use to build their case, then you decide of those things what you want, and you request them from them. Now, I'm not going to go through all of these things since we're well past this stage, but you can always pause the video here if you want to read all of these. But this is a pretty good sample of what one looks like. This was a sample I found from Sacramento, California. But these are tangible evidence. Things like phone records, emails, photos, contracts, electronic files, things like that. March 14th was also a due date for interrogatories. This is a sample of one from that conspiracy case that I report on. This is also based on the list that they've provided each other, and it's the questions that they want to ask about those things. So in addition to the actual discovery, they want to know more about it. So these kind of work together, and they have the same deadline. Our next deadline is April 18th. This is the deadline on motions to amend or to join additional parties, which pretty much is exactly what it sounds like. And now we get to the one that I think was the culprit in confusing everybody. This one is called substantial completion of document production. So this is not a true deadline. This is just kind of like a reminder that, hey, we're starting to get close to the deadline. Get that discovery rolling. Because remember, in the episode about depositions, I told you that you might, in the course of a deposition, find something that you didn't know about before. And based on that, you're going to need to ask for discovery. So yes, there will still be requests for discovery at this time, all the way up to the deadline. So for example, one type of discovery is third-party discovery. That takes place with subpoenas. We saw some content creators ridiculously get subpoenaed yesterday, and it could be their depositions. Lots of things that you still may need right up to that deadline. So it's not the deadline. But here's the thing. Turning in discovery can get out of hand. Sometimes it's done as a strategy. Sometimes it's just a lot of stuff. But when it gets out of hand, like this case here, it can end up messing up the entire schedule. We see in this, there was a deadline for May 15th, but one side had only produced about 1/3 of the total production. And in fact, discovery was closing up, and so it messed up the entire flow. So there had been the deadline for summary judgment on February 5th, but it was so backed up, it got moved all the way to April 30th. In another case, the judge here sees that problem about to happen, and he tries to get ahead of it. And he puts this order. He says they should not be dumping the bulk of these remaining documents on plaintiff at or near December 5th substantial completion deadline. So the court will simply order that between now and December 5th, defendants should produce their remaining ESI discovery on a consistent, roughly proportional, rolling basis, such that plaintiff does not get the bulk of the remaining documents at or near the deadline. So that's how discovery is supposed to go. It's supposed to be rolling. So a constant flow of little bits. It's not supposed to be big dumps and then nothing and big dumps and then nothing, but ongoing. So through the process, if there's an issue like that, and that's where these motions to compel came in, to get that discovery in. And this judge really wanted to make sure that didn't happen, so they put a couple of markers in here. They had one date where they should be 50% of production, and another date they should be 75%. So you can see this can be a big problem in courts, and they really don't want that to happen because it can mess up the whole schedule. Because if one side is not turning it in, they leave the other side to a disadvantage. So that's the deadline we just passed. So the actual discovery deadline is coming up on August 14th. And they really prefer all the tangible evidence to kind of be in by that deadline, even though some may still be waiting. But the bulk of that should be done by then so that at this point in time they can focus on the depositions. And so that deadline for both the fact discovery and the depositions is August 14th. And there's another thing due on the same day, and that's called requests to admit. This is another form. And just like the interrogatories that were supposed to be filled out under oath, these are as well. These are submitted to each other just like interrogatories in the form of questions. They're trying to establish facts that they agree on, and this is going to save them a lot of time. It will save them time at the trial, and it will save them trial prep. So if they can get each other to admit as much as possible, it leaves less things to work out in the actual trial. Anything that they deny, they have to explain. If the honest answer is that they lack knowledge or information to answer it, they can answer that way, but it must be truthful. And you have to answer them sufficiently, or motions can be filed to make you answer them again, just like the motions to compel. If these are not answered within 30 days, they're considered to be admitted. The next deadline is a couple of months later, and that's for expert discovery. So once they get through all of this fact discovery and depositions, then it moves on to the experts, which is exactly what it sounds like. In this case, we might see people like intimacy coordinators, forensic data extraction experts, because we have the issues with Jennifer Abel's phone. Now, this list got shortened a lot when Justin's case was dropped. Also, when Blake dropped her emotional damages, that would rule out needing mental health experts. But it would be any kind of expert like that. So that type of discovery picks up after the regular discovery, and that ends on October 15th, and since that's the final step, that ends all of discovery. A lot of you have asked what happens if they don't submit the discovery that they're supposed to, or if things are submitted but they're incomplete or damaged. So we heard something about some missing metadata. There are punishments for these kinds of things. They can be sanctions. That's things like having to pay the other's attorney's fees or having to pay fines. It can be very extreme and lead to a case being dismissed. But there's another term I want to introduce you to, and it's called adverse inference. That deals with the damaged or lost things, things that don't get turned in. Adverse inference means that the jury can be instructed to view these things in a way that infers that there was something wrong with them that made someone look guilty, and so it was destroyed. Whether that's the case or not producing it can lead to that. And imagine you're on a jury and you're told that this stuff wasn't handed in, or it was handed in damaged or incomplete, and it looks suspicious, and you were instructed to look at it that way. That's going to make you look at the whole side suspiciously, so they don't really want that to happen. And that's a difference between criminal cases and civil cases. In criminal cases, it's the opposite. You're instructed not to. But in civil cases, it's a really bad thing. And just less than a week after that, they have their post-discovery status conference. Just like there was a conference at the very beginning, there's another one at the end. There will surely be matters that need clearing up. And before this conference, a week before the conference, they have to submit a joint status update. So they have to speak about the things here: deadlines, due dates, cutoff dates, any outstanding motions, the status of the discovery, if there's anything that remains to be completed, if there are any settlement discussions, how long they think the trial might be, and whether or not they intend to file motions for summary judgment. Anything they want to address, they put in this brief that they have to make together And it's all things like this. They're instructed to do it together, and if they're unable to do part of it, they can reach out to the court for help. But after this is submitted, then a week later, they will come together with the judge and discuss those things and get everything settled. Deadlines for motions for summary judgment will be about 2 weeks after that, and then we have the joint pretrial order. So if the case is not resolved through summary judgment and they are moving on to a trial, they have to come together again and make another document, a joint document, and that's called the pretrial order. This is all of the things pertaining to the trial. Again, they've got to do it peacefully. If they can't, the judge will step in and help. But once this final document gets submitted to the court, it will become an order. It's things like jurisdiction. So like in this case, we have multiple lawsuits within a lawsuit. It's down to just a few things now. But they have to decide choice of law. Is this going to fall under New York law? Is it going to fall under California law? We started off with quite a few causes of action on each side. Some of those have been dropped already. So whatever's left for plaintiffs' claims, whatever's left of defendants' claims, stipulation of facts. So that's the things that people admitted to. And then issues of fact. That's the things that were denied. Those are the things that will be fought out in the trial. Evidence problems that may arise at the trial. Is there something wrong with some of the evidence? Are there issues with some of the evidence? Do they object to each other's evidence? If they do, and they always do, there will be what's called motions in limine, things that each side wants the other side to not be permitted to use at the trial. So there will be some more squabbles over that, and the judge will rule on those if they can't come to agreement on their own. There will be finalized witness lists. There will be the exhibits that they plan to use, damages that they intend to ask for, whether or not they want a jury, how long they think it will be, if there are things that they can't cooperate on, all the aspects of the upcoming trial. And then that will be decided in this order, and that will become the actual order from the court. And that's pretty much all we have now. Other issues, of course, could come up in the meantime. But that's the basic outline for beginning to end. And we've seen most of this already at this point. So I made this at the beginning, and it did circulate just a little bit. I'm going to post it in my community tab as well. So you're welcome to download it, you're welcome to share it, or just keep it to refer to, or come back to the community tab when you need to refer to it. But I hope it helps keep in mind exactly what the rest of this trial is going to contain, and what each step that we've completed and each step we still have left are, and what to expect from them. This is Cassidy O'Connell, saying stay well and stay tuned.